At Symphorien-Saavedra Law, we believe that every immigration story is unique. Immigration law is more than just a service, it's our sole and passionate focus. With over 4 decades of combined experience, our dedicated team is here to walk beside you, helping individuals, families, workers, and investors navigate every step of their U.S. journey. We take on small cases, large cases, and everything in between, always adapting with flexibility to meet your needs. Our expertise spans work and investment visas, family immigration, humanitarian visas, asylum and deportation defense, citizenship and nationality, and federal court litigation. At Symphorien-Saavedra Law, we love what we do because for us, immigration isn't just about paperwork, it's about people, dreams, and new beginnings. And we firmly believe your future has no boundaries. Let us guide you toward achieving your goals in the United States.
All right. Well, good afternoon, everyone. Thank you for joining us on this beautiful Wednesday afternoon. My name is Frank Symphorien. I'm a board-certified immigration expert and the founder of Symphorien-Saavedra Law. And I have the privilege of having my esteemed colleague and senior associate counsel, Evelyn Pabon Figueroa. Welcome to our first, I guess this would be your first participation in our live, right, Evelyn?
Yes, good afternoon, and thank you for that great welcome. Yes, it's my first time doing a live with you.
So everyone is in for a treat. Evelyn is super experienced. She's been doing this for longer than I have, if you can believe that. A little bit longer, not that much longer, as you can imagine, with her young looks. But we've been doing strictly immigration. Well, I've been doing strictly immigration law for over 18 years. You've done a little bit more than that, right? Some business, general commercial litigation as well. Is that right?
Yes, as well as some bankruptcy.
Right. So she's got a little bit broader experience, and which is great, right? When you're doing national interest waiver and you're entering this field where business activities and business acumen is important. She's also managed some law practices, right? Which is also helpful when you're intersecting that with immigration law and business. And so we are really privileged to have you. Evelyn is doing a lot of our national interest waiver as well as our extraordinary ability petitions, right? And that's one of her principal focus these days, although we are doing some federal court litigation quite a bit as well these days. But thank you again for joining us, Evelyn. So everyone is here for a treat. We're going to get it going. We've got 30 minutes of substantive, discussions involving natural interest waiver. I think we have our first question, which is, can someone qualify for a national interest waiver even if they don't have an advanced degree? Evelyn, I'll throw this one at you and I'll chime in after.
Yeah. The short answer, yes. Someone can qualify even if they don't have an advanced degree. The national interest waiver is for people that are in the employment-based second preference category. That includes people that have advanced degrees, such as masters and PhDs. People can qualify as having an advanced degree if they have a bachelor's degree plus 5 years of progressive experience. But it's also available for people that have exceptional ability in the sciences, arts, and business. So even if the person does not have an educational degree, but they can show that they have exceptional ability, they may still be able to qualify for the national interest waiver.
Yeah, and it's one of the exceptional ability criteria is one of the most interesting criteria because it's not quite as high extraordinary ability, right, for AB1A petitions or R1 extraordinary ability petitions, but it's exceptional and it's pretty flexible, right? I mean, in reality, a lot of people qualify. 10 years of professional experience is one of you have to meet 3 out of, I think it's 8 or 10 criteria, right? One of the criteria is just having a bachelor's degree or having a license to operate in the field of endeavor or having 10 years of a professional experience or being a member of professional groups. So it's a quite flexible criteria that a lot of people can really meet. If you just have a long career and a long, track record of achievements in your field, it's actually pretty flexible, right? So a lot of people qualify. To answer that question, you don't have to have an advanced degree, and there's essentially three ways, right? Three paths, as you mentioned: the bachelor's degree plus 5 years of experience, the exceptional ability, 3 out of 10 criteria, and then there's the master's degree, which is also always the easiest path, right? It's important to know that you also can have a foreign equivalent, right, for for the master's degree or the bachelor's degree. So it's one of those criteria that is pretty flexible. Now, the challenging part for a lot of these is the second step, right? The DANASAR standard showing the extraordinary the national interest in the field of endeavor. So I think we can move on to the second question, Sydney. All right. What is the biggest misconception people have about what national interest actually means? It's a good question.
It is a good question. I think there are a few. One of them is that people sometimes think that it only applies to like very specific categories of work. And as long as you can show the previous requirements that we talked about, as well as that meet the remainder of the DANASAR requirements, it applies to different areas such as healthcare, technology, the sciences, businesses, education. So but a lot of people think they think technology. That's one of the things that people a lot of times think, and that's not true. Another misconception I think that sometimes people have is that just being very, very good at what you do and having a fantastic track record will be sufficient. Here, you have to keep in mind that you have to show a benefit to the U.S. So it's not just about what you've done, is what you are going to do in the U.S. and how that is going to benefit the U.S.
Yeah, that's definitely really good. Along that path, I would sort of go backwards, right? So I think in some ways, sometimes the misconception is that everyone qualifies, right? There's this thing that everybody who has and there's a lot of TikTok videos and a lot of things out there that kind of explain, hey, if you have a master's, you qualify. If you have if you have any long experience, you qualify. No, the reality is that it has to be something that has a national significance. And it is in all fields. There's a lot of fields out there, but there are fields that are easier to establish than others, right? So there's prior memos, certain memos out there from the government that emphasize STEM careers, right? Science, technology, engineering, mathematics, or science. Those are generally, by and large, going to be a little bit easier. But it's important to note, to point out we could probably go back and forth about some of the most interesting professions that you've gotten through the National Interest Waiver category. One of the ones that I've seen a friend of mine did was a makeup artist, right? It was which you would never think, right, that you could qualify and show that something that's national interest. But she was really creative, and she did this based on somebody who was doing in the television industry, and so she was able to create a national scope to this endeavor and win the case. I've done people in the sports field, right? There's a lot of people, even though you wouldn't think, hey, this is a traditional STEM field, but I've done people in the sports area, in athletics. Have any interesting categories that you've done before, Evelyn, that you can think of?
I think most of the ones that I've done have been more in the science and technology area. Okay. Right. Nothing as interesting as that makeup artist that you just mentioned.
Yeah. So you can get really creative. Now, I will say this. There's been some pullback, right? There's been a lot of probably a course correction, because for some years there was a little bit of too much creativity, or maybe abuse, you would say, of the National Interest Waiver category. And so some of those more creative areas are getting harder and harder to probably get approvals on. But you can still be creative, and you can kind of push the envelope and kind of develop the law in this field, right? It's important to note that before that the concept of national interest has changed over years, right? So before, a few years ago, probably before the Danisar stand, several years ago, it was a case called New York Transportation Department, and that, you know, the way that the government construed national interest was pretty narrow back then. And the whole purpose of the Danisar standard was to make it a little bit more encompassing, right? Have a broader reach, and explain that it's not just STEM fields that qualify, but you can have other fields of endeavor qualify beyond just the STEM fields. So, so thanks for that input, Evelyn. Anything else that you want to add to this question?
Not at this moment. I think you covered everything. I think we did a good job with covering the misconceptions.
Perfect. Good. All right, let's get to the next question then. Can an entrepreneur or business owner qualify for an NIW without working for a U.S. employer?
Yes.
Take that one to you.
Yes. That is one of the benefits of the National Interest Waiver, is that you do not have to have a job offer. You can self-petition yourself. Now, if there is an employer, the employer can still petition you under the National Interest Waiver. You can have a job offer, but it's not necessary. And that's the kind of like the beauty of the National Interest Waiver, that you can move forward without having an employer or a job offer from someone here in the U.S.
I will say it's a very important factor or consideration, though, right? I think one of the, if we can point out another misconception out there in TikTok and social media and so forth, a lot of times they talk about, oh, like anybody can qualify if you have an engineering degree, or if you have a degree in STEM fields, right? But unfortunately, there's a lot of people in Latin America that may have that degree, but aren't actually pursuing it or working in the field of endeavor, right? So I will say that this makes it much more challenging. Like the government, if you haven't worked in engineering over 10 years, and now you're saying you have a national interest endeavor that you want to move forward, you're going to probably have some difficulty and challenges in establishing that you are well positioned to carry out that proposed endeavor, right? Because the government is going to wonder, well, if you're so great, why haven't you been working in the field over the past 10 years? 5 years, right? So having an employer is not required, or a sponsor, but it's certainly helpful to have one, because in many ways it can validate. It's part of the criteria. The second step as to how well positioned you are. The standard actually asks the interest of U.S. employers, interest of interested parties in your proposed endeavor. So if you can have an employer, or if you can have third parties that can validate the significance of your proposed endeavor and your particularly unique skill set, it's going to help quite a bit in carrying out a lot of the work for the National Interest Waiver. I think that's good for that question. I'll let you take us on this one, Evelyn.
How important is your future plan in the U.S. compared to your past achievements when applying for a National Interest Waiver?
Well, I would say it's equally important, if not more important. I mean, it's kind of two parts. It's a three-part test, and this question encompasses basically the first two, right? So the first part of the test is you have to establish the importance of your proposed endeavor and how your national it will reach, what national scope it will have. So that future plan and how you frame it is critical. It's probably the most important thing is how you frame your future plan, because it can't just be that you're working as a scientist in research, or you're working in, robotics. That is not a proposed endeavor. That's a field, or that's a profession, right? So you're going to have to really frame the question appropriately as far as what that future plan is, and explain how it's going to have some sort of national reach. Usually the plan itself, the importance of the plan is not the hard part. Usually the challenging part is establishing that national reach or that national scope, right? And so that's the first part, I would say. And then with regards to the second part of this question, your past achievements, well, that goes to the second set of standards, which is how well positioned you are to carry out that proposed endeavor. which is, the second element of the Danaher test. And so, if you have somebody, as I just explained, if you have somebody who past achievements were 10 years ago or 15 years ago, it's going to be a challenge to establish that those 10 or 15-year-old achievements are relevant to your current proposed plan, right? But if the achievements were relatively recent and they're significant and they're relevant, they're directly tied to your future plan, that's going to be really important. And I always tell people that, the second element of the Danaher test is in many ways almost indistinguishable, I think, from the extraordinary ability petitions, because your credentials, your past achievements, and how impressive your career is going to do a lot of the heavy lifting with regards to the second criteria.
Yeah, I agree. And I think I do agree that they're equally important. And the past achievements also come into play before we even go into the NIW part. If you're, for example, applying as the exceptional ability person, they are going to look at your past achievements and what you've done. That can be considered and that can be useful to determine if someone meets the requirements for the EB2, which you initially have to meet those before we even go into that discussion regarding the National Interest Waiver.
That's a good point, yeah, because you have basically a double dipping, right, in terms of your achievements with exceptional and then your position in the field. Perfect. Yeah, that's a great point. All right, I think we're ready for the next question, Sydney.
What types of evidence carry the most weight with USCIS in a strong NIW petition?
So I tend to think of this as very similar to the EB1A category in many ways. I tend to think that, for the most part, the immigration officers don't know your field, right? You can do this in any field. So they're not engineers, they're not scientists, they're not researchers. They're not going to be experts in your particular field for the most part. And so a lot of times I think what carries the most evidence are things that are relevant for the extraordinary ability petition or the O1 criteria, which are things that carry third-party vetting services or third-party authenticators of the significance of your credentials. So even in the extraordinary ability petition category, where you have like articles from leading authorities, from the New York Times and from the Wall Street Journal, right? If you have something about that, that is vetted by the journalistic integrity of the New York Times, right? And so if you have an article that's written about you that has that third-party vetting, built in, that's going to carry a lot of weight. Obviously, if you have leading authorities, leading experts in the field, right, that are recognized, that's extremely helpful. Governmental support letters are extremely helpful. One of the things that I think is underused are economic analysis, right? And many times I try to find, in all of my cases, I try to find two experts. One is a substantive expert, right? So if it's an engineer in, for example, chemical engineering or petrochemicals, right? Petroleum engineering, which is one that I did. It's also, usually I'll try to do somebody, a couple of, at least a few experts in the substantive field of engineering in oil. And then we would also try to do anybody that's doing research or analysis on the economy, the economic components of that industry. Right. So in one case, for example, I used an economics professor that was specializing in oil and gas and was able to kind of carry out, explain the significance of the national scope, right, of that particular field and the proposed endeavor. Right. So economists, not always, but in many cases, if you're trying to establish that national scope, that national reach, the expert letters are really important. And then I would just say leading authorities, whether it's, because it's a newspaper that has vetted, expertise or vetted recognition as having an independent view of your career, or if you have experts, letters supporting evidence, it's really important that the people establish that they are leading authorities in that field. Anything you can think of?
I would also add things like, if you're working in an area that is of particular interest for the government. Like, let's say the White House has put out statements regarding that there's this critical areas that is of interest that for the White House, for the national security, for just the nation as a whole, and that's what you're working on, then I would include those documents from the government that that support the fact that what you're doing is of national importance. If you already have contracts with clients, potential clients, I would include those. If you have sources of financial sources, you have people that are already, going to invest in what you're working on. Those are items that I would also include as well.
Yeah, and that's sort of like the verifying part that I said, right? So, if somebody's investing in your money, that says a lot more than somebody who's promising you whatever, right? So there's a different element of validity to that, because that person is invested. And it's a great point about the government. It's you can kind of put their own words at their face and say, well, you said this was a national interest, or this was, an area where America needs to be more competitive. And needs to have more people in this field. So that's great. All right, so we got another question. What mistakes do you see applicants make before they even file an NIW petition? This is a good one. I have my answer right away, but you can go ahead, Evelyn, first.
I think, sometimes just thinking that, their resume alone will carry them. As you mentioned earlier, sometimes people think, well, I have these degrees, or several years ago I worked in this area, but they haven't worked in the area for several years. And now they think that that's going to help them with the National Interest Waiver. I think that's a big mistake that people make. I'm kind of curious to hear what yours is, because you seem to have been very ready for this question.
Well, I would say, for me, it's always the framing, right? You got to make sure that you are framing the right field of endeavor. And like I said, I think for a lot of people, they make this mistake in assuming that just because they're an engineer, or because they're a doctor or a veterinarian, or whatever their profession is, that is going to be a strong, or that's going to carry the day. It's very similar to what you said. But I do think that the framing of the proposed endeavor, because one of the biggest kickbacks that we always get from the government is saying, what you're proposing may be very beneficial, but it's going to be beneficial to a particular employer, or the field is it's a profession, and there's nothing specific about what you're doing that's going to that's going to benefit the nation as a whole. Yes, the general category, the general field, the general profession may be helpful, but that's not specific to you and your proposed endeavor. And I think that's always the challenge. I mean, it's always making sure that you are presenting the right field and asking the right question. Giving the government officer kind of, because your framing of the field gives the officer the proper question, right? Are we presenting a field, a profession, or are we proposing an actual endeavor, or a project that you're actually going to carry out? And that project will have some tangible, real benefits, right? Not just abstract, like I'm just researching, whatever. If you're a professor, you've got to try to, probably. Make it a little bit more tangible and more specific, so that we can kind of see the benefits to the country.
I think people should also be ready to explain what their plan is, what they do in simple terms at some point in the entire process. Because as you mentioned earlier, the officers are not necessarily experts in the area of the applicant's expertise. So yes, these applications have a lot of technical information, but the person has to, at some point, we need to explain it in simple terms that are easy for an officer to follow, and then show how all these other technical information that is added, the more technical documents, how they support each of those allegations, but presented in a more simple way, understanding that you're not talking to an expert in your field. You're talking to an immigration officer who will be evaluating your plan.
Perfect. Yeah, that's a great point. I don't really have anything to add to that. So we will move on to your next question. If someone receives a national interest waiver denial, what factors determine whether it's better to appeal, refile, or pursue another immigration option?
Well, the first thing is to, really review that denial and determine what the basis of the denial was. If after reviewing that denial and reviewing the petition and all the supporting evidence that was submitted, you understand that USCIS made an error, then you can move forward with appealing. However, if you realize that there wasn't sufficient evidence, then you might want to reconsider refiling. Or you also might want to reconsider whether you actually meet the requirements for that category. Because not everyone meets the requirements for national interest waiver, and the reality is that maybe another employment-based category will be better for that person. But the first thing is just read the decision, analyze every position raised by USCIS in their denial, and then based on that, you determine, well, was it their mistake? Did they not properly evaluate the evidence, but the evidence is there and it's strong and we can appeal it? Or no, the evidence is not strong and it's a better option to refile. I think you also have to take into consideration other factors, such as the effect that a refile versus an appeal will have on things like priority for visa availability purposes, whether the person is here in the US or whether the person is outside of the US. So there are several different factors that have to be taken into consideration when you decide which is the best position, which is the best action to take if you receive a denial.
Yeah, I agree entirely. I think not all denials are written equally, right? So if you have a very narrow denial that's focused on a legal issue, whether your particular field of endeavor, the narrower the scope of the denial, the more likely, I guess, if it's legal in nature, then I think you kind of want to, move forward, in my opinion, with an appeal, right? If it's a narrow legal issue, you could potentially file an appeal. But, you point out some really important points that if you have, for example, dependents are going to age out, right? Then you may have to file an appeal. You may not have an option of refiling because if your dependents have already aged out and there was some protection because you filed it while they're still underage, then with Child Status Protection Act, then you could, you may have to pursue that appeal. The priority date is a great point. If you file for adjustment of status with the national interest waiver, which some people have done in the past, and they're probably doing it now since the August bulletin is now current. That's one of the things that it's not specific to the national interest waiver, but it's probably one of the biggest mistakes that I ever see with national interest waiver. There's a pattern out there of some notaries or people that are not experts in the fields that they try to tell you file the adjustment application with the national interest waiver, and you can stay and file, and to me that's kind of putting the carriage before the horse, right? You really want to make sure that you protect and preserve your underlying status. If you're a student, keep your student status. If you have an H-1B, keep your H-1B status. And don't do it, the adjustment of status, until you've secured the national interest waiver is approved. And then you have a strong standing to move forward with adjustment of status. Not to mention all the new recent memos that talk about why people should not be pursuing adjustment of status from the US. So I think it's a very fact-specific question. You got to look at the denial. One of the things that we have some statistics on out there that there's ways to figure out is, who is the officer that issued your denial, right? Sometimes you can track by the officer number, if you think you're going to have a better chance with a different officer. If you had a request for evidence, what was the scope of the request for evidence? So this is probably a challenging question because it's going to be very fact specific, but a lot of factors are going to play, a lot of the factors that we're discussing are going to come into play. All right, I think we have quite time for maybe one last question. And
can someone change employers or become self-employed after filing a national interest waiver petition?
So I think the answer to that is, and I get this is probably a question that is important to clarify out there, right? That the National Interest Waiver petition does not give you work authorization or permanent residence in and of itself, right? You're going to have some underlying non-immigrant visa status that allows you to work with a particular employer. You're going to have, whether it's an asylum application with a work authorization pending or something pending that allows you to work, because the National Interest Waiver petition is not going to give you the basis to stay in the United States or to pursue employment until it's approved and until it's combined with an application either for consular processing that gives you a green card or adjustment of status, right? Sometimes the adjustment of status, if you file it concurrently with the National Interest Waiver petition, it'll allow you to work. This is one of those things that we don't recommend. I don't think anybody should ever do that. For the most part, file the National Interest Waiver concurrently with the adjustment. Unless the children are aging out or something like that, it's generally not a good idea because you're going to kind of be left out in limbo. And if your National Interest Waiver happens to be denied, one of those really problematic misconceptions out there is that, you can appeal. And yes, you can appeal the NIW denial, but you're not going to be able to appeal the adjustment of status. And so even while the appeal is pending, you're going to start accruing what's called unlawful presence, and you're going to be barred from being able to enter the United States or for changing your status in the future. So you can change employers for sure, but please understand that you're changing your employer is kind of independent and separate from your NIW petition. Or becoming self-employed, because as I said, your NIW petition alone is not going to give you the right to work or be self-employed. Anything else that I missed that you want to add, everyone?
I agree with you. I think it was very important that you pointed out that unless you have employment authorization through some other source, you're not just having a pending or filing an NIW petition is not going to grant you the employment authorization, and you're not able to work. And I think it's very important for people to keep that in mind when they're undergoing this process, and to protect any status that they currently have in the U.S. while all this process is taking place.
Yeah, and I think I'll make one final point on, and it's kind of going back to what's one thing that I wish people knew, or the biggest misconception out there with National Interest Waiver. TikTok, social media, a lot, it's pushing this idea that, if you have an asylum application pending or whatever, that you can still do an adjustment of status and you don't have to leave the United States. That kind of, is all the product of probably a case called Matter Well Pay, which kind of opened the door to potentially some people in specific circumstances where they had not been, summoned to appear in immigration court. They had filed for asylum on time, that potentially some of those people maybe could adjust. The reality of that case and of the law is that just because it said that some people could not qualify for adjustment of status or changing their status from National Interest Waiver to a green card holder did not actually mean that everybody else could, right? So it was a negative inference that a lot of people are making online and saying, oh, if you have an asylum application, you filed it on time, and you don't have court, you qualify for adjustment. It's not true. In the current environment, if you have an asylum application and you're not from a barred country, there is the possibility of doing consular processing, but for the most part, your chances of changing status or adjusting status, if your status has lapsed and you filed for asylum, are very, very small, if not insignificant, or impossible under the current administration. I haven't seen any adjustment of status approved for people who are, not in a valid period of a lawful status with a valid I-94 in the past 18 months. Have you seen any of that, Evelyn? I don't think.
I have not. I have not seen any of that.
So,
and the other thing that I've seen, with people that I've done consults with and spoken to, another thing that's very important kind of along those lines is like, if you lost your status, you entered with a visa and you lost your status and, you have done nothing and you've accumulated unlawful presence, then you might need a waiver before you do the consular processing. And if you don't have the required qualifying relatives, you won't be able to get the waiver that will allow you to leave the country and then come back in. So if it's very important for individuals that at some point did not have status while they were here in the US, don't have an asylum application pending, it is very important that they consider that and they remember that if they have unlawful presence, they might need a waiver. And if they don't have a qualifying relative, they won't be able to get a waiver.
And with that final point, I'll bring up one last point that I want to make, which is, artificial intelligence is amazing. It's great. I use it every day. I encourage our staff and everybody around to use it, to learn it. It's the future, but it has a ton of flaws. It doesn't catch nuance, and it's all about asking the right question and framing the right question. So I would caution, we get it every day, people that want to do their own national interest waiver or they want to do their own adjustment of status. And, a lot of intelligent people can figure things out, but I will tell you this, that it's never been more complicated in the history of our country, I think, to practice immigration law, right? And I would say that, people that are considering using AI or using notaries and so forth to file national interest waiver, I think should tread very carefully. They should research, in my opinion, you really need a qualified, experienced attorney to handle these very complex areas of law. Evelyn is amazing. I encourage you to reach out to her, contact her. She's available for consultation. She's actively handling various national interest waiver matters. And so I would strongly encourage you to have a consultation with Evelyn because she's amazing. You can also, if you'd like a consultation with me, we're actively pursuing these national interest waiver cases. And you can reach us at the number on the screen, which is 407-802-1717. Or you can reach us by email or on social media. And Evelyn and I are both available to meet with you. So with that said, Evelyn, I want to thank you so much. I know, this is not your favorite, but I think you did an amazing job. And, one of the things out there is that, in my opinion, there's a big difference between being great at marketing and being a really good lawyer, right? There's a lot of people out there that market and like talking and going on social media. But I'll tell you this, a lot of really good lawyers are probably the best lawyers are the ones that do the day-to-day work like you do, Evelyn. And I commend you for that, for helping so many people and doing the complicated substantive work of expanding the law and helping people achieve their dreams. So thank you everyone for joining us. And again, we will be doing this every second Wednesday of the month, right? I believe it's every second Wednesday of the month. So I encourage you to stay tuned and catch us on the next live, which should take place in the second Wednesday of September. Okay. All right. Take care, everyone. Thank you, Evelyn, again.
Thank you. Have a good day.